afternoon about challenging misleading competitor advertising. And I'm very happy to, by the way, I'm a partner at Lewis Silkin in the United Kingdom. I'm in partnership with Geraint from the previous panel. And on this panel, I'm going to be joined by my friends and colleagues, Caroline Bouvier from Bejot in France, Daniel Haije from Hoogverraad and Haak in the Netherlands, Kelly Harris from Thomson in Canada. And although I can't yet see him, I hope my colleague Uri Weinstok from BLP Legal in Costa Rica. The question is, what are we going to talk about and why should you bother to listen? So what we're going to talk about is how you can challenge misleading advertising by a competitor, but not the kind of comparative advertising that uses your trademark and which lends itself therefore to a fairly conventional action for trademark infringement subject to the various defenses around the world that are available for comparative advertising. What we're interested in is where you see a competitor trying to get a competitive advantage by making misleading advertising, but that doesn't expressly name you. It may imply a reference to you, it may not, but either way, it's causing you damage and you want to put a stop to it. And what we have found is that in some countries, that can be best done through the legal system, and in other countries, it can be best done through the self-regulatory system. One of the other things is that this is an area where GALA has really proved itself to be a very, very valuable resource to advertisers in tackling cross-border advertising. And we've built this presentation around a case study from 2015, where I worked very closely with Daniel on behalf of Garmin in order to prevent some misleading competitor advertising by TomTom. So that's going to be the framework for this conversation. And I should add at the beginning that there is this article that was published in the international journal, the International In-House Council Journal. It was co-authored by the General Counsel of Garmin, Andrew Etkind, by myself and my then colleague, Dan Bugler, and by Daniel Haije. It's a lengthy article. It's about 12 pages long. It goes into a lot of detail. So I would say don't trouble yourself to write lots of notes during the course of this presentation, because it's all in the article. And you can obtain a copy of the article either from Stacey Bess or from myself or from Daniel. We'd all be very happy to give you a copy. And so what we hope you'll get out of it and why you should bother to listen is that you'll understand how you can shut down misleading comparative claims or competitor claims without relying on trademark law, and particularly where there's this cross-border element where the ad is being controlled from another country. The types of misleading ad, therefore, just to really repeat that point, there are these different types of misleading ad that are set out on this slide, but I would, as I say, make the point that what we're talking about specifically are the ones where your trademark's not being used. As I say, there's this case study. Now, the main claim that Garmin were concerned about was a sort of overarching campaign, or claim rather, that TomTom gets you there fastest. But this was then supported by some specific claims. The claims also appeared in two media. There was this leaflet which set out, and this was available in store for people to take away. And this was definitively within the jurisdiction of the Advertising Standards Authority in the United Kingdom. So this didn't give rise to the jurisdictional problem. But that came with the complaints on their website. And in order to attack this TomTom gets you there fastest claim, we then had to kind of dig down a level and look at some of the underlying claims. So this was what we called the coverage claim. And TomTom claimed that there were these four features: coverage, reliability, accuracy, and frequency. And they didn't actually make a frequency claim, partly because the Garmin data updated more frequently than the TomTom data, so they just were quiet about that. They did pick out these others. They claimed they covered more roads, and we said, well, that's misleading because although you cover more roads, most of those are very, very quiet rural roads where the data isn't really of any value because there's just too little traffic. They made a claim about the reliability of the data based on the number of users they had. And we said, well, hang on, that's not a like-for-like comparison. You're comparing the number of users in the UK with the number of users internationally. So that's just a simple, not like-for-like comparison. They also made this claim about accuracy, and we said, well, it's all very well claiming to be precise down to 10 meters, but actually what the driver needs to know is not exactly where they are in the traffic jam, but how fast is the traffic jam moving? And this data doesn't really convey that. So we said this was misleading in the way it was presented. Finally, before we get into the review of the legal and regulatory options, there was this other claim which was interesting. So this was a testimonial, a piece of user-generated content. And this person who places reviews on Amazon, calls themselves Dark Cell, posted this view. TomTom is, in my opinion and experience, provide better traffic updates than any other manufacturer. And we said to TomTom in the initial first stage of the dispute, where we wrote to them setting out our views as a necessary precursor to submitting a complaint to the Advertising Standards Authority, we said, you've incorporated and adopted this piece of user-generated content. It's therefore become an advertising claim for which you're responsible, and you can't substantiate this claim. And actually, to be fair, TomTom did accept that argument, and so there was a kind of early success in this dispute, was that TomTom agreed that they would remove that from their website. So before we move on, just to clarify this point, was the website a British website or a Dutch website? Now, you logged on to tomtom.com, but then the computer read your IP address, recognized in my case that I was based in the UK, and sent me to these specific GB pages. Pricing was in sterling. The claims used UK maps, for example, and UK performance. All the cultural references were English, so the characters referred to had English Christian names. There were images of left-hand roads, and so on and so forth. So it was clearly being directed at the UK. But the Advertising Standards Authority said, we don't care. As far as we're concerned, there's only one website, and that website is a Dutch website because TomTom is a Dutch company. And we tried to say, well, hang on, the marketing department's in London. And they said, no, we don't care. It's a Dutch company. Take your complaint to the Dutch regulator. Why were they doing that? We suspect because these kinds of competitor complaints between great big corporations use up a huge amount of the ASA's resource, and our sense was they just didn't want to get involved. They wanted to give the problem to the Dutch rather than having to deal with it themselves. And they said, we'll look at your leaflet, but we're not going to look at your leaflet until you've had the ruling from the Dutch about the website. So go and deal with that and then come back. And they referred us to the European Advertising Standards Alliance website and their rules about cross-border complaints, which adopt the country of origin principle, and which does say quite clearly that for online advertising, for what they call digital advertising, you apply the country of origin principle by saying, well, where is the advertiser based? And in this case, clearly, TomTom is a Dutch company, so it was based in Holland. The only good thing I will say about this ruling is that since then, I've used this ruling to get lots of my clients out of trouble with the ASA, if they're based particularly in the Republic of Ireland, by saying, well, terribly sorry, you don't like our advertising, but actually you've got no business looking at it because we're an Irish company and therefore you need to send your complaint to the ASA in Ireland. So a happy outcome with that. So that's a quick sweep of the background. The legal action, I'm not going to go into the options for legal action in the UK, save to say it's a lot easier in this scenario to go to the Advertising Standards Authority, to go down the self-regulatory route. I'm going to hand over straight to Caroline. Can you talk to us about the options there in France about commencing a legal action in this scenario?
Yes, thanks, Brinsley. The first question which will have to be answered is whether or not France has jurisdiction, as you explained. And as far as an online ad is concerned, French judges will have a look at the website and whether or not the French market is targeted. For instance, if you have prices in euro, information pertaining to retailer in France, the use of the French language, then you can bring a claim in France. Then you have to decide on which ground you will sue your competitor. So if the competitor or if your client is identified either directly or indirectly, you can file a claim on the ground of misleading advertising, which basically impose that the comparison is based on objective criteria. And you, of course, you must not disparage your competitor, and the claim must be true and accurate. And if the brand name is not featured on the ad, but if you can indirectly identify the competitor or your client in our case, for instance, if there is only one competitor over the market and people can clearly understand whom you are talking about, then misleading comparative advertising rules apply and will have to be complied with, and you can sue on that ground. If on the contrary, as you explained, there is no comparison element, then you can file a claim on the ground of unfair commercial practices. And if our clients suffer the prejudice, then we can ground our claim for unfair competition, which is tort law, and to be awarded, for instance, monetary damages, and to try to have the ad banned or at least discontinued. And then we'll have to discuss with the client what he's looking for. If he wants cheap and fast action, does he want monetary damages? Does he want to damage the competitor reputation, or discontinuation of the ad campaign? Then, depending on what is what the client wants, we'll have to different option. Actually, we can, for instance, send a letter to the Consumer and Competition Agency to have them launch an inquiry against the advertiser. And the letter will have to be specific enough to encourage the DGCCRF, which is the name of this French body, to have the DGCCRF launch the inquiry. And during the investigation, the DGCCRF will require the advertiser to provide it with some documentation and any document which aim at proving that the claim was true and honest. And at the end of the investigation, the DGCCRF is able to issue a cease and desist letter to have the campaign stop, and failing to comply, the advertiser could be sentenced to pay a penalty, which is a civil penalty. But the DGCCRF is able to suggest to offer to the advertiser to enter into a settlement agreement, in which case the advertiser undertakes to discontinue the ad campaign and to pay a penalty. And at the very end, the final decision of the DGCCRF will be published on its website. So if you want to damage the image of your competitor, it could be a good way. But the disadvantage is that, for instance, the client has no control over the decision which could be taken by the DGCCRF. And the procedure usually lasts a long time. And if, for instance, the breach is serious, then the DGCCRF is able to share the matter with the French prosecutor, in which case he will decide whether or not criminal action will be launched against the advertiser, in which case criminal penalties could be ordered against the advertiser. So at the very end, our client or plaintiff has no real control over the procedure, whether or not the DGCCRF will launch an inquiry or whether or not the prosecutor will launch the criminal action. So it's a good side for the publication, but bad side because you have no real control and it can last a long time. So then we can file a claim before French courts, in which case commercial courts will have jurisdiction if two companies are having a dispute. So we can try and have a summary proceeding to obtain rapidly the discontinuation, the withdrawal of the ad campaign. But the breach must be obvious because in summary proceedings, judges do not review the merits of the case. So they just answer if there is an obvious breach of the law, or if, for instance, the competitor is disparaged in the ad, then they can decide that the ad be discontinued, ad campaign, or the ad be discontinued or stopped. But otherwise, we'll have to, your claim will be rejected, and you will have to file a claim before French commercial courts, but on the ground of the merits of the case. So the advantage of summary proceeding is the fast option, but you need to be sure to be able to evidence that the breach is obvious. Otherwise, we have to file a claim on the merits before commercial courts. So if you want, we are running, yeah.
Can we wrap up this part for France, and we'll move on to the Netherlands?
Yeah.
Thanks, Brinsley. Thanks, Caroline. So in the Netherlands, in terms of legal action, it is possible to file a claim against your competitor with the Dutch civil courts when there is a case of comparative advertising, which would be the case when you refer, or in an ad, a competitor is referred to, literally by name or by implication. So then the basis would be the Dutch civil law or civil law, which implements the comparative advertising directive, which is which harmonizes this field of law in the whole of the EU actually. So then that comparative advertising directive and the Dutch civil code contains basically 8 conditions that have to be fulfilled for an advertiser, for a comparison to be lawful. And most notably, it can be misleading, it can be disparaging, etc. But Caroline already addressed those subjects. So, what if you're not identified in the ad, even indirectly? Well, that wouldn't be comparative advertising, right? But you can actually, you can file a claim against your competitor in the Netherlands if that's the case, because basically, it is considered unlawful if your competitor has a competitive advantage when he or she or it breaches the rules of fair competition or fair. So if there's an unfair marketing practice by your competitor, then you will have a basis for action. Now, which sanctions could you obtain in a typical comparative advertising case with the Dutch courts? But typically, you would file for summary proceedings, which take about 4 to 6 weeks in the Netherlands, can be even quicker, and you would file for an order to discontinue the ad, rectification, and possibly damages, but although that's pretty difficult to get in summary proceedings. So that actually one nice fun fact about the Dutch courts and the summary proceedings procedure in the Netherlands is that the Dutch summary proceedings judge will issue a cross-border or a pan-European injunction even against Dutch entities doing comparative advertising, the same comparative advertising across different member states of the EU, because the Dutch courts find that when it's unlawful in the Netherlands, it will be unlawful in Germany, France, etc., because of the harmonization of the law, and they will issue a prohibition across the whole of Europe. So that's
and Daniel, that's actually a really interesting point that I wanted
Yeah.
just to focus on for a moment, because in the UK, when we implemented the Unfair Commercial Practices Directive, we didn't include a standalone right of enforcement by private companies in the way that I know they did in the Netherlands, and I believe they did in Germany. So it's quite an interesting option. It does mean there's this possibility of going, if you're a British advertiser, going to the Netherlands. Well, if particularly, obviously, if the people making the comparisons based in the Netherlands, go to the Netherlands, use your private legal right, which you wouldn't have available to you in the UK anyway, and then get a sort of, well, perhaps not these days, not, well, still pan-European or pan-EU, but unfortunately no longer capturing the United Kingdom necessarily. I don't think neither you nor I have examined that point, but I think we
continental Europe. Call it continental Europe.
Yes, yes. So I know you're a little bit isolated over there, but you get pan-European. Daniel, if it's all right, I think at that point we'll transfer to the Americas, and first of all to Kelly, who's going to tell us about the situation in Canada.
Wonderful, thanks, Brinsley. So from the Canadian perspective, there are a number of causes of action that could be raised to address comparative advertising in the courts. A key cause of action typically would, of course, be based in trademark. But since that's not the focus of our discussion, the first key cause of action to consider would be our federal deceptive marketing practices legislation, which does provide a private right of action for those who have suffered damages due to criminal misleading advertising. So access to the statutory private right of action does require proof of damage, and is also predicated on the underlying misleading advertising meeting that criminal standard. Generally speaking, the criminal offenses for misleading advertising do mirror the civil provisions that the regulators would rely on for their enforcement. But on the criminal offense, usually a knowing or reckless mens rea is added. So in addition to this key statutory cause of action, we also do have common law causes of action that could be the basis of a comparative advertising action. So for example, defamation and similar torts like, injurious falsehood, as well as the torts that are based on economic law. So, the tort of interference with economic relations. As an aside, we do also have provincial consumer protection legislation, which provides a cause of action for deceptive marketing practices for consumers, but that wouldn't be available for advertising competitors. So based on these causes of action, you can see that it would be pretty difficult for an advertiser to come up with a persuasive case if it's not identified in the ad, even indirectly. Even if named, it could be very challenging to prove causation for damages due to a competitor's misleading advertising. And if the advertising doesn't name the competitor, proving any market loss or other damage would be all the more difficult. So when it comes to sanctions, the main remedy is damages, but this type of action can take several years to complete, during which the claim, of course, would still be in the market. So typically an advertiser would seek an injunction to stop the advertising pending the resolution of the action. So while it's certainly possible to get an injunction, technically in these circumstances, the standard that the challenger has to meet is very high. So the relevant motion in Canada would be typically a pretrial interlocutory injunction, not an injunction as a remedy, to stop the conduct until the court has provided its final decision in the underlying matter. So the advertiser would need to have the underlying claim underway and then file the motion for the injunction. And the timing to get that would depend on the court's calendar, but it can be fairly quick to schedule. But the standard is high. So the court's only going to grant that interlocutory injunction if the plaintiff can prove that there's a serious issue, that the plaintiff will suffer irreparable harm without the injunction, like permanent market loss, and that the balance of convenience is going to favor issuing the order. So it's a pretty high standard to meet, essentially requiring the plaintiff advertiser to prove that the injunction is required to stop a harm that couldn't otherwise be compensable in damages. So when you're assessing a strategy to address comparative advertising in Canada, the strict legal tests, both to get an injunction and then for the underlying action, as well as the unpredictability of it, it often dissuades advertisers from seeking court action. And of course, time is a factor. So courts can be slow, and that might not be a desirable route of attack on that basis. And then, of course, cost is a key factor because it's expensive to file a legal action. And with an interlocutory injunction motion, a lot of that expense would be upfront to prepare more detailed filings that, compared to the filings in the self-regulatory process, which we'll get to next, I'm sure, so I won't go into.
Thank you, Kelly. That was really very, very clear. And I think a lot of what you said there resonated with me, and I'm sure with the other panelists. Those sorts of considerations, I think, are ones that would be applicable pretty much everywhere. Uri, now you're obviously joining us from one of the most beautiful and ecologically diverse countries of the world, Costa Rica. But I think we're also going to get some insights from you on a wider scale of Central and South America about some of the legal options. At least I hope so. If that's wrong, then you better correct me immediately.
No, that's actually right. And actually, there will be some generalization in what I'm going to say because it will cover some different jurisdictions, and we cannot go one by one. So there may be some specifics in certain countries that may not apply, but what I'm going to discuss here is like the general rule that applies on these cases in a typical Latin American jurisdiction. Basically, on the type of action that you may bring, it really depends on your cause of action. Like in a case like the one you presented, you could bring three different causes of action. Or more than one jointly. The first one would be comparative advertising. In that case, a competitor will have standing to bring the claim if they can show and they can convince the judge that this is a comparative ad and they are the ones that are being compared, which in implied comparisons can be a challenge sometimes, but generally, if you can show that you're reasonably the brand that you're being compared with, then you may bring a cause of you may bring the claim before the judge. Another cause of action may be unfair competition. In that case, you must show that that there is some harm, not necessarily monetary damages because they're difficult to estimate, but you need to show that you are being harmed by the ad somehow, in order to be able to bring the claim and to have standing. The third one is a little bit trickier, which is misleading advertising, because sometimes the judges are reluctant to accept claims brought by competitors based on misleading advertising, because they're saying, no, you do not have standing to represent consumers, and only consumers can claim that they are being misled. So generally, the cases here would be to include all three, and then you would include the misleading advertising arguments, but they would not be your primary cause of action, because then your standing may be questioned. There are other ways of bringing the claim, which are also the consumer protection authorities. In those cases, the standing works the other way around. Normally, they don't like companies bringing claims. Normally, they pay attention to consumers, and they care about whether or not consumers have been misled. So typically, before the consumer protection authorities, claims are brought by either a consumer or a consumer association, very rarely by a competitor, but sometimes it happens as well. On the type of procedure that would be advisable, normally as everywhere, courts tend to be slow. So if you're bringing a case before a court, the advice normally would be to try to get an injunction, which is quicker. And typically, if the claimant would try to obtain first the injunction and then file the complete lawsuit. So if the injunction is not obtained, they don't file a lawsuit and there's no harm done. And that would be the end of it. Another option would be to go to the consumer protection agencies that in most countries in Latin America, they have like a quick pre-procedure option that if there are no health issues involved and there's no danger to the safety of anyone, they would just reach out the advertiser and ask them if they're willing to change the ad or to remove the ad. If the defendant is willing to play and they just take the ad out, that would be like a very quick resource if that's what you're aiming for, just to get the ad taken down. Now, if they don't want to play ball, then they have to open a full procedure and it would take longer, and then the remedy would not be as effective as you would think. Another risk of bringing the claim is that sometimes, and sometimes this is even promoted by the own defendant, the cases get very public. So sometimes, even if you are able to take the ad down, the noise around the case would create a similar effect as the ad being shown. So that's one consideration to be taken into account. How public do you think the case will be? Because otherwise, the purpose of the plaintiff bringing the claim, even if an injunction is obtained, would be like contradicted by all the news and the publicity around the case that will just reinforce the misleading message, or the message that you consider that is misleading. In terms of the remedies available, as in other countries, courts can order the ad to be removed and can also order the payment of damages. The consumer protection authorities can also order the ad to be removed. They cannot award damages, but they can impose penalties. That would be like a quick overview of what generally you would find in a typical Latin American jurisdiction in terms of legal action.
Okay, that's very helpful. Thank you. I mean, I think bringing together the threads of what everyone's been saying, basically, the legal route is the kind of high risk, high cost, high reward option. It's going to cost you a lot more money than going to a self-regulatory body. It's potentially going to be a quicker outcome. And therefore the reward is, you know, the name of the game often with these things is to, if you're the advertiser, is to try and complete your media schedule. And when we're acting for advertisers, that's whether that's in the courts or with the self-regulatory body, with the ASA, what we're trying to do is to drag things out so that we can complete the media schedule. On the other hand, if you're the complainant, you're doing the opposite, and you're trying to do everything you can to bring the thing to an end as quickly as possible. And the challenge sometimes can be deciding, is that going to be best achieved through the courts, or is it going to be best achieved through the self-regulatory organization? I believe there are certainly people registered on this call representing organizations that were party to an ASA investigation, a competitive complaint. I was acting for the advertiser, and my job was to try and get the media schedule completed. 3 years later, boy oh boy, had the media schedule been completed, to the point where the advertiser started to say, actually, we sort of need to know where we stand now. So it would sort of actually be helpful if we knew whether we were going to win this case or not, because we now are planning our next campaign and we still don't know whether we're going to be able to make these claims. So that was a case of be careful what you wish for. I'm wondering why my slides aren't moving along. Oh, I don't know what's done that. Regulatory action, here we go. So we're going to move on to then the next point about whether you can go to a self-regulatory organization.
Brinsley, sorry to interrupt. I do think we need to show that CLE code for folks looking for New York CLE credit.
Even before okay, we're only partway through, just so you know. That's the code word. And I know that Paola gave you some kind of other code, which
Paola was just testing whether people were paying attention or not by giving people the number of the slide to make sure that people really earn this daily credit. But all you need to do is make sure you get the word regulation. That's what they need for this one.
And that's the kind of subterfuge that James Bond would have been proud of. No one's going to work out regulation as being the code word for a presentation on regulation. I think that's called hiding in plain sight. So the regulatory action options, and this is just a list of questions. Rather than having loads of slides, we decided we would just put up some of the key considerations. And actually, you know, we'll sum up at the end, but one of the key ones, which I think I'm guilty of having missed off the slides, but I was reminded of when I reread the article that I mentioned, was burden of proof. That's a really key one, particularly in the UK, which is that if you go to the ASA, you effectively reverse the burden of proof. So you're the complainant and you can go to the ASA, as in this case, Garmin, you can go to them and say, look, under the advertising code, it's up to TomTom to prove that their advertising claims are not misleading. It's not up to us to prove that they are misleading. It's up to them to defend them and prove that they're not misleading. The burden of proof is on TomTom. And that, of course, gives you an immediate advantage as the complainant. So I'm going to go back to Caroline and ask you, I think you've said previously that it's less of there's less options, but just before we go to the others, can you just clarify for us the position about going to the self-regulatory organization in France?
Yeah, so a competitor can file a claim with the SRO, which will only assess whether or not the SRO's guidelines have been violated. So there is a general rule which sets forth the true and honest claims. So and more specific guidelines regarding vocabulary in ads, which provide that you can say you are the best, or you are the leader, or you are the number one if you are not able to prove that. So yes, you can file a competitor or can file a claim against the advertiser. And as you said, for the UK, the advertiser will have to show to the jury's SRO that he is able to evidence the fact that he, for instance, he is the leader of other markets. But the French, but the jury will not review whether or not the claim is true and whether or not it's really the best over the market. It will just ensure that the advertiser is able to evidence this element. So there is slight difference. So basically, companies are reluctant to go before the SRO because the sanction is the publication of the decision on the website only. So it's a name and shame sanction. So the jury does not have the power to find advertiser who breached the codes. And usually advertisers do comply and discontinue the ad, or at least amend the ad. But from a strict legal standpoint, the jury's decision may not be enforced against the advertiser as a court decision would be. So the advantage of the procedure is it's fast, it's cheap. There is a key procedural advantage, as you said, for the UK. But in the end, there is only a publication on the website, so sometimes it's not the best option for clients. That's it for France.
Thank you. I think Daniel, do you want to go next about the Netherlands?
Yeah, sure. So the Netherlands has a self-regulatory body. It's called the Advertising Code Committee, and you can file a complaint. Competitors can file a complaint about comparative advertising. There's not a really hard sanction. I mean, the Advertising Code Committee can issue a recommendation to discontinue this type of advertising, this kind of advertising. But the scope is only the advertising concern, so the advertising, the specific piece of advertising that is subject to the complaint. And and this all sounds, this doesn't sound really impressive, right? But but there is an amazing compliance rate. So there is like a 97, 96% compliance rate when the Dutch Advertising Code Committee issues this recommendation. It's complied with, generally speaking. There is a naming and shaming system so the recommendation can get published, or all the decisions are public and they're published in this archive. But when there's a really bad case, then the Advertising Code Committee can issue like a press release. And it's often used as well to like test the waters for civil action. So that's an advantage as well for going to the SRO in the Netherlands, because the Advertising Code Committee decisions have a lot of pull with the civil courts. So when the Advertising Code Committee says an ad is misleading, and Dutch civil courts will generally follow suit, and they will judge that it's misleading. So
that's interesting. Just on those things, you said some things which do highlight the differences between different countries in these areas. So I think the English courts won't pay a lot of attention to an ASA decision, and they would tend to say it's up to us. You know, we're the court, we're the senior partner, if you like, in this relationship, and so and also the English courts have more of a bias towards free speech, and they'll be more inclined to lean in favor of free speech argument, whereas the ASA tends to be very paternalistic and think that consumers are easily misled. But something else you said about compliance also made me think that compliance in the UK with ASA decisions is also very, very high. What I've never experienced, but it's an interesting idea, would be that we have this thing, it's a bit like defamation, called malicious falsehood. The difficulty in using it is that the advertiser will say, well, you know, in this case, for example, Thomson would have said, but we don't think we are being untruthful. We think that we can substantiate our claims. So there's no malice. We genuinely believe in our claims. Fair enough. But if you got to the point where the ASA has upheld a complaint, and then in this example, TomTom had continued to run it, then I think it would be much easier for Garmin to go back to the courts and say, well, hang on, they're continuing to run a campaign which the ASA has adjudicated against, so they know that it's misleading, really. And so by continuing to run it, we now have a private right of action, which is a much stronger claim than we would have done.
Oh, makes total sense. I mean, I'm not an expert on UK law. You are, Brinsley, but it sounds really good.
I cut you off. Do you want to just finish the points you were making?
No, yeah, sure. You know, it's a good. I mean, so the reputation of the Advertising Code Committee is really good with the civil courts. There's actually, you know, there's case law in the Netherlands saying, you know, specifically saying that we don't know it any better. We, the court, you know, the Advertising Code Committee has judged that this is misleading. So they're really proficient in this field, and let's go with it. So that's basically it's really informal. It's really quick. So it's a good procedure. It's really popular in the Netherlands. So yeah.
Okay. I'm going to hand over to Kelly. Kelly, one question I've got for you is that whether when you go to your self-regulatory body, is there a possibility of an oral presentation? Because one of the differences between the UK and the Netherlands that we discovered on this case was that in the UK, the system does not allow, they don't have meetings, you can't go along and make a presentation. Whereas in the Netherlands, Daniel did go along and effectively had his day in court, as it were, and made his presentation. What's the score in Canada on that point?
Well, it's a good question, because it used to be oral arguments were accepted, but the procedure changed very substantially a couple of years ago, and now everything is done by writing. So there's 4 volleys of submissions, and then those 4 submissions are given to the panel to adjudicate. as of 2019. So those who aren't familiar, Ad Standards is the self-regulatory organization in Canada. So it administers, like in many other jurisdictions, the Canadian Code of Advertising Standards, and it offers 2 dispute resolution platforms. For advertisers, it's the advertising dispute procedure. And under that procedure, advertisers can resolve, competitive and other concerns, and really concerns that their competitors are contravening the code in their advertisements, which I'll get back to later. Notably, there's also a consumer dispute resolution platform, and Ad Standards does pre-clearance for broadcast advertising in regulated sectors in Canada. And the sanctions are kind of similar to other folks. Really, if an advertiser is found to have contravened the code, the dispute resolution panel will request that the defendant amend or withdraw the advertising. There's no financial or legal sanctions otherwise available to the SRO in Canada. If an advertiser doesn't comply or doesn't even participate in the advertising dispute, which has happened before, then Ad Standards can elect to name the defendant advertiser in its published case summaries, which are otherwise anonymous, which I think is another point of departure in Canada. If all things go according to the procedure, Ad Standards will publish a case summary, but it will be anonymized. And in fact, the publication of case summaries is also new to the procedure as of 2019. Prior to that, there were no case summaries, and all the process was entirely confidential.
Let's just pause there for a moment, because that, I think, is really important. Again, an interesting point of difference between these procedures internationally.
Mm-hmm. Yeah, no, I agree. And I think Brinsley, sorry, go ahead.
No, it's just astonishing, because I think in the Netherlands and in the UK, the key sanction of the self-regulatory system is reputational damage. And you have to change your campaign or end your campaign. But apart from that, it's reputational damage. And yet you're saying to us that in Canada, it's all done confidentiality, so there is no reputational damage for the guilty party.
And I think the reason for that is really the procedure comes, and the roots of it and its objectives are to resolve disputes. And I think it in amending the procedure 2 years ago, I think that was an intentional choice to keep it sort of meant to be a dispute resolution platform between advertisers to correct the market and not be used sort of as an aggressive tool. But I think it is an interesting point, because it makes the Canadian procedure a really useful or interesting potential first port of call when you're planning a global strategy. If you've got claims around the world and you're thinking of challenging in multiple jurisdictions, because the Canadian procedure is confidential, a challenger advertiser could feel things out in the confidential Canadian procedure before taking a bigger risk in more public jurisdictions or taking court action in other jurisdictions. Obviously there's downsides to the confidentiality rule. You can't use it as a name and shame, and you can't use the outcome publicly as part of challenges in other jurisdictions. But of course, the information is known to the organization and can inform future actions. Maybe I'll just, given the time, I'll kind of summarize some of my other comments here. There's a lot of procedural requirements, but one that I found in our discussions to be also unique to Canada is that there's no requirement in Canada that the complaint be about comparative advertising. Any code violation could be grounds for a complaint. And our self-regulatory code mostly mirrors legal requirements. So there's prohibitions against deceptive claims, requirement to substantiate your claims, but there are some provisions in the code that address social issues, like the ones that were discussed in our previous panel, in Paula's panel in the last presentation. So prohibitions against unacceptable depictions that are discriminatory, racist, sexist, that sort of thing. So as a practical matter, most self-regulatory challenges are going to involve a comparative or performance claim, because there is a cost associated with it. It's $10,000 Canadian, give or take, depending on a few factors that the complainant advertiser has to pay, plus your legal fees. But it's not a requirement that the underlying advertisement involve comparative or performance claims, or even name the advertiser. Probably unlikely that someone's going to bring a claim just based on an unacceptable depiction. But it is an avenue there, right? So even if there isn't a comparison, the Canadian process is very much open, unlike the comparison to the courts.
Okay, that's great. Thank you. And again, you've just highlighted one interesting point about the filing fee, because in the UK, certainly there's no filing fee at the moment. I should say that the system for competitive complaints in the UK is under review. It's been under review for literally, I think this may now be the 3rd year. So we're waiting with bated breath to see what changes, if any, will be made. And one of the ones under consideration is about requiring a filing fee. Mm-hmm. So I'm going to...
Well, and Brinsley, to make another UK-Canada comparison, the timeline in Canada is also a huge advantage. So you have to pay, a filing fee plus your legal fees, but they have a procedure timeline. It's all very strict, and from start to finish, the standard timeline is 37 working days from when the complaint is filed to when the decision is issued. So speed is obviously a huge advantage in Canada compared to court actions, and you can get in and out of the Canadian procedure very, very quickly.
Yeah, yeah. And I can see the relationship between those things, that by requiring some money from the advertiser, it then allows the SRO to dedicate the resources to prioritizing the matter.
Yeah, and the panel is chaired by a lawyer and 2 members of the industry, so it's a pretty high level analysis.
Right, right. So I'm going to now just ask Uri to tell us the situation in Central and South America. And while he does that, just quickly mention, if you've got any questions, just drop them into the Q&A panel on the right-hand side of your screen. Uri.
Yeah, thank you, Brinsley. In Central and South America, or in Latin America in general, I would divide the countries in 2 groups. The first group is where there are self-regulatory bodies that exist and are functional and have credibility. And then the second group, which is countries that either have them, but they're not widely used, or do not have them at all. If you count the number of jurisdictions, I would say that both groups are about half and half. But if you count the size of the economies or the population, all the large economies do have self-regulatory bodies that have a lot of credibility. I think that the most interesting example is Brazil, where interestingly enough, most of them are named CONAR or a variation of the name. But if you run into the same name in the different jurisdictions, just be aware that they're different organizations. They just have similar names. But for example, CONAR in Brazil, it has a lot of jurisdiction, and the self-regulatory code is used by the judges in court as a source of interpretation of the law. Or, for example, in other countries, that it is widely used. Examples of those are Brazil, Argentina, Mexico, large economies with a very functional and effective self-regulatory body. A special case would be Peru. I would mention that they do have a functional self-regulatory authority, but the Consumer Protection Agency also has a lot of credibility, which is unusual in these jurisdictions. So a lot of people go to the official authority, not because they do not believe in the self-regulatory system, but because the official channels have a lot of credibility as well. In most of the cases, as you explained in other jurisdictions, the decisions are not binding, but are widely abided by the parties. And I'm talking about the first group, the ones with the functional self-regulatory bodies. So they're normally obeyed, and it does have a lot of credibility. And in some places are known also that to be a very good element in a future litigation if you brought the claim successfully to the self-regulatory body. For example, in countries like Mexico and Chile, it's known that if you do have a positive decision by the SRO, and then you bring a claim to the judicial system, you're starting with your right foot, because it's like half the game is already won. Also, most of the decisions are publicized because of what Kelly called the name and shame effect, and that's what it really does have. Even if it's not binding, the fact that they're published do make them more likely to be obeyed by the parties.
Great, thank you. So I think we're just going to take a second to wrap up, just draw some of these threads together. For the purposes of this slide, I used the acronym ASA, but you could take that to be any of them. And you can see some of the pros and cons. And of course, as we've heard, it varies a lot from country to country. There are some differences. And I would add the key ones on there about the burden of proof. And the difference in the burden of proof is worth thinking about, as well as these basics about speed, cost, sanctions. And also, I think it was Kelly who touched on this really important issue that when you're deciding what you want to do, you do need to bear in mind, well, what happens if we make this complaint, but we fail? And British Airways found that when they made a complaint about Ryanair to the courts, they went the legal route first time round, and the court made a very kind of pro-free speech decision and said, oh, well, maybe this is a little bit misleading, this advertising. But consumers don't believe advertising anyway. Consumers just assume all advertising is lying, so they weren't misled. A very robust view, one might say, but it was embarrassing for British Airways, because the outcome was that, you know, not only did Ryanair say they were cheaper and better, but the courts apparently agreed. So you do need to bear that in mind as well. This is just a screen grab of the article that I mentioned, which I believe was actually distributed to everybody in advance, so you should already have that, but you can still email me or Daniel. We'd still be delighted to hear from you. The only real question that's come up from our colleague Duncan in Ireland is about legal costs. I mean, I think in most countries, the loser pays the winner's costs in the courts, and one of the key advantages of the self-regulatory system, I mean, A, the whole thing costs a great deal less, even with filing fees. I think it costs a great deal less. And B, if you lose, you don't face the prospect of having to pay your opponent's costs. But, you know, to do a good job with the ASA, it does take a fair bit of work. It's not, you know, it's not a low-cost thing. And like everything, the more time and effort you put into it, the better your prospects of success. So with that, I think it just remains for me to say very, very large